The Judiciary Committee will please come to order, a quorum being present. Without objection, the Chair is authorized to declare recess at any time. Pursuant to Committee Rule 2 and House Rule 11, Clause 2, the Chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote for the yeas and nays are ordered. I'd like to remind members that we've established an email address and distribution list dedicated to circulating amendments, exhibits, motions, or other written materials that members might want to offer as part of a markup today. If you'd like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as possible. I would also ask all members, both those in person and those appearing remotely, to mute your microphones when you are not speaking. This will help prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. Pursuant to notice, I now call up H.R. 7946, the Veterans Service Recognition Act of 2022, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 7946, to provide benefits for non-
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 7946, the Veterans Service Recognition Act of 2022, would finally ensure that non-citizen active duty military veterans and their families are treated with the dignity and respect befitting the sacrifice they have given to this country. As we discussed at our hearing last month in the Immigration Subcommittee, immigrants have served in the U.S. Armed Forces in every major conflict since the Revolutionary War. Every day, 45,000 immigrants actively serving in the U.S. Armed Forces risk their lives in support of our country. While military service can offer an expedited pathway to naturalization, many non-citizen service members leave the military without becoming a U.S. citizen because of unnecessarily burdensome requirements that they must meet. Further, many service members have family members who lack lawful status in the United States with no ability to adjust their status. As a result, while our military personnel are deployed protecting U.S. global interests and keeping our nation safe, they must worry if their loved ones will be apprehended in an immigration raid and potentially be deported. We must do better by those who risk their lives to protect our country. President Biden has taken significant actions to remove barriers to naturalization for service members. Additionally, the Departments of Homeland Security and Veterans Affairs have collaborated to create the Immigrant Military Members and Veterans Initiative. This initiative helps immigrant veterans across access VA benefits and, when appropriate, apply to be paroled into the United States. In addition to the Biden administration's actions, there has been a bipartisan commitment since 2007 to protect immediate family members of U.S. service members and veterans through the Parole in Place in Military Families Initiative. However, more must be done, and that is why we're considering H.R. 7946 today. The Veterans Service Recognition Act would direct DHS and DOD to implement the program that allows non-citizen service members to file for naturalization during basic training or as early as otherwise possible. Establish the Military Family Immigration Advisory Committee to review and provide recommendations on the cases of non-citizen veterans, active service members, and their families who are in removal proceedings. Provide an opportunity for non-citizen veterans who have been removed or ordered removed and who have not been convicted of serious crimes to apply for legal permanent resident status. And 4, allow immediate relatives of service members or veterans with an approved immigrant petition to adjust their status and obtain a green card as long as they are otherwise admissible. This legislation recognizes and honors the sacrifices of our service members by supporting them and their families and by giving them every opportunity to become U.S. citizens if they so desire. This is modest but important legislation that deserves bipartisan support. The Veteran Service Recognition Act is a narrowly tailored solution to a specific problem. The number of deported veterans is a closed universe with a small and finite number of individuals who are eligible for relief. DHS estimates that the number of deported non-citizen veterans is in the hundreds. Additionally, by addressing the naturalization of non-citizen service members during basic training, this bill will eventually eliminate the need to assist deported veterans in returning to the United States. I'd like to thank Chairman Takano of the Veterans Affairs Committee, as well as our Immigration and Citizenship Subcommittee Chair Zoe Lofgren, for their leadership on this issue. I was honored to join them in introducing the Veteran Service Recognition Act, and I urge all my colleagues to support this important legislation. I now recognize the gentleman from California, Mr. McClintock, for his opening statement.
Thank you, Mr. Chairman. DHS Secretary Ali Mayorkas has repeatedly asserted, including in sworn testimony to this committee, that the southern border is secure. Now, this, of course, is a lie, and not even a very subtle one. We know the numbers. A stunning 3 million encounters since Inauguration Day, when Joe Biden reversed the Trump administration's enforcement measures, with roughly half of these admitted and trafficked to every community in our nation. Another 900,000 known gotaways. We're all seeing the effect of these policies, the strain on our schools, our hospitals, our public safety, working class wages and opportunities, social services. No civilization, to my knowledge, has ever survived the magnitude of illegal mass migration on the scale that the Democrats have unleashed in just 18 months. And Gallup warns there are another 42 million people in Latin America and the Caribbean who intend to come here now that they can. Well, when Mayorkas appeared before this committee, he couldn't tell us how it benefits the American people to have their classrooms packed with non-English speaking students, their emergency rooms flooded with illegals demanding basic care, how their families will be safer with increased gang activity and fentanyl inundating communities, or how working families will be made better by flooding the labor market with cheap illegal labor while they foot the bill for social services. How do our Democratic colleagues react to this unprecedented illegal migration that they've unleashed? Do they call on the Biden administration to stop the releases? Do they call on the president to actually enforce U.S. immigration laws, or at least stop incentivizing this mass illegal migration? No, they mark up this bill that readmits immigrant veterans who were later deported, mainly for committing criminal offenses. Using veterans for cover, they go on to provide that any alien who adjusts status to or is admitted as a lawful permanent resident shall be presumed to have established good moral character. What? The effect of this will be that millions of people per year will be presumed to have satisfied their good moral character burden simply by producing their green card. The legal permanent residents who enlist in our military are offered special avenues for naturalization under the Immigration and Nationality Act. About 3% of U.S. veterans today are foreign-born. Many have chosen to become U.S. citizens. Now, for a while, we allowed non-legal permanent residents, including those here on student visas, refugee claimants, and DACA recipients, to enlist in order to claim a fast track to citizenship. It was called the MAVNI program. It was such a debacle that the Obama administration had to suspend it in 2016. One MAVNI enlistment, Ji Jiaqun, was found to be a Chinese spy. A number of foreign nationals who enlisted in our military were subsequently deported for committing crimes. Now, foreign nationals who come to America legally, who obey our laws, and seek to serve our country because of a love for it and the principles upon which it's founded, are one of our greatest strengths. 11 years ago, I spoke at the funeral of Gurpreet Singh, whose family had immigrated from India legally 11 years before that. His father told a reporter that Gurpreet was, quote, always a very patriotic man for the U.S. From the time he was a little boy, he knew he wanted to serve in the U.S. military. Gurpreet was very proud of his service with the Marines. Well, Corporal Singh was wounded in combat, chose to return, overstayed his assignment to relieve a friend, and was killed in action in Helmand Province, June 22, 2011. Yet the majority seems unable or unwilling to tell the difference between a Chinese spy like Ji Jiaqun and an American hero like Gurpreet Singh. I pray the majority is not attempting to equate such heroism, devotion, and fidelity with the lawless, illegal mass migration they're not only ignoring, but actively aiding and abetting with their policies. 31,000 foreign nationals now serve in our armed forces. This is less than 4 days of border incursions that we're currently seeing. The IMMVI program has naturalized about 1,000 veterans over the last 16 months. That's the number of illegal aliens streaming across our border every 3 hours. H.R. 7946 does nothing to address the chaos on the U.S. border, makes major changes to U.S. naturalization law, and it furthers the Democrats' anti-enforcement agenda. For those reasons, I oppose the bill, and I yield back.
The gentleman yields back. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 7946, offered by Mr. Nadler. Strike all that follows after.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I recognize myself to explain the amendment. This amendment in the nature of a substitute makes one substantive change along with a number of technical changes. The main change is the addition of a new section which allows immediate relatives of service members or veterans with an approved immigrant petition to adjust their status and obtain a green card as long as they are admissible. The new section waives certain admissibility requirements related to how these individuals entered the United States and is consistent with the Parole in Place initiative that has existed since 2007 for military families. With regard to the technical changes, they are all minor and designed to ensure that the legislation is implemented as intended. For example, the Sense of Congress section is deleted and various small changes were made to the reporting requirements of Section 2. I urge all members to support the amendment, and I yield back the balance of my time. Are there any amendments to the amendment in the nature of a substitute? What purpose does the gentlelady from California see?
I'd like to strike the last word, Mr. Chairman.
Gentlelady's recognized.
I want to just briefly encourage all the members of this committee to support this important bill. You know, there are many challenges that face our country in the immigration arena, but this is a discrete situation that we can fix. You know, the American Legion, not exactly known as a left-wing organization, has come out strongly in support of this measure. Why? What they have said in their letter to us is that American veterans should not be deported and removed. Now, most of the veterans who have been removed from this country, who served their country in the U.S. military, were legal permanent residents of the United States, and after their discharge, they messed up. In many cases, related to PTSD that they developed because of their service. People who got involved in, and they would be arrested and convicted. Well, unlike their U.S. citizen veteran colleagues, after they were held accountable for whatever they did that was wrong, they were then kicked out of the country. Well, you know, what the American Legion is telling us is hold people accountable, but veterans, people who served our country, should not be thrown out of the United States. I know, as the chairman has said, there is a discrete number of individuals in this situation, and the administration has been on a parole basis reviewing them. But I'd like to note that these individuals, in many cases, matter of fact, in most cases, have families in the United States, American citizens in most cases, who are left in the U.S. while their family member is waiting in another country, and it's a hardship on those Americans as well. I would like to note that there is a program in place administratively since 2013, and since that time, the USCIS has approved almost 40,000 applications for military parole in place. Let's note that 2,000 of those applications were approved by the Trump administration. So this is an area where we could come together and put people over politics. Let's honor our veterans. Let's honor their families. Let's make sure that even if we can't do everything, we can do this one thing that will make us stronger, that will honor the service of people who served in our military and their families. And I want to thank also you, Mr. Chairman, for your support of this effort, as well as Representative Takano, the chairman of the Veterans Affairs Committee, and also Congressman, our colleague, Lou Correa, who has been such a leader in standing up for veterans and who has visited the veterans, American veterans who are stranded in Tijuana, hoping to rejoin their families here in the United States. And with that, Mr. Chairman, I yield back.
The gentlelady yields back. Who seeks recognition? For what purpose does the gentlelady from Texas seek recognition?
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman, and thank you so much for bringing this very important bill to the table. You know, I don't want us to get distracted with other issues. I mean, this is a very narrow issue about something that really, quite frankly, should have never even happened, that people get deported after serving our country. I think it's time that we put veterans ahead of politics and veterans ahead of partisan politics and vote to support our veterans. By marking up this bill today, House Democrats continue to deliver on our promises to the American people. To all our deported veterans, know that we see you, know that we stand with you. You fought for our country, now we're fighting to bring you back. A todos nuestros veteranos que fueron deportados, sepan que no son olvidados. Los esperamos de nuevo en casa con brazos abiertos. Mr. Chairman, I simply said that we support them and that we're working hard to bring them home. We have a moral obligation to those who have served our nation in our armed services. Since the Revolutionary War, immigrant service members have continued to fight in every major conflict throughout our history. That obligation is not limited only to our military members, but extends to their families who support our veterans. All of us have family members in the armed forces, who have family in the armed forces, know the pain and the sacrifice of seeing our loved ones head overseas to fight for our liberty without knowing when we'll ever see them again or if we'll ever see them again. If you're willing to put your life on the line to defend this country and its values, you should be able to become a U.S. citizen. This bill simply says that it all begins at basic training. And if we don't do this, it will continue to be totally unacceptable that service members who risked all their life to protect us are thanked for their service with an order of removal. In my view, they should be rewarded with a medal. Those who have served our country, paid for their actions, and who do not pose a threat to our community should not be condemned to exile. They should be allowed to process their pending immigration proceedings within the United States, the nation they swore to defend, and risk their lives. As they are morally entitled, they should receive the comprehensive health care benefits that veterans are eligible to receive. I commend the efforts of the Biden administration in dignifying our veterans and service members who have served and sacrificed for our country. The Immigrant Military Members and Veterans Initiative has taken significant steps in the right direction. I thank the leadership of Congressman Takano and our chairwoman Lofgren on this issue. We had a great hearing over I think it was over the holidays, and it clearly, this bill is one where we need to put our veterans over politics, support them, and welcome them home. I urge my colleagues to support this legislation. With that, I wanted to also, Mr. Chairman, introduce two articles for the record, if I could get unanimous consent. The first is the U.S. has deported thousands of veterans. A new policy change offers new hope for our soldiers left behind. The second one is particular to Texas. These veterans from Texas were deported. They say they deserve a second chance. I agree with them, Mr. Chairman, and I ask for unanimous consent for the record.
Without objection.
Thank you, Mr. Chairman. With that, I yield back.
Gentlelady yields back. Who seeks recognition?
Mr. Chairman,
For what purpose does Mr. Biggs seek recognition?
I have an amendment at the desk.
Clerk will report the amendment.
I reserve a point of order.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.R. 7946, offered by Mr. Biggs of Arizona. Page 8.
Without objection, the amendment will be considered as read, and the gentleman is recognized for 5 minutes to explain the amendment.
I thank the chair. My amendment requires the Military Family Immigration Advisory Committee and the Secretary to consider the victims of crimes when deciding whether an individual should receive the benefits of this bill. As drafted, the bill focuses only on the deported individual, And the bill does not even mention the potential victims of crimes. We know that most of the individuals who were removed from the country were removed because they committed crimes. If there was a criminal conviction, and if there was a victim, then the advisory committee should be required to consult with the victim, and the victim should have to agree that the individual warrants that the individual deserves an exercise of discretion. In other words, in most states even, we consider restitution, we consider the victim's voice in these matters. So if you've been removed because you've committed a crime against the victim, it'd be my position that the victim should be heard on the issue of reinstatement, if you will. The committee should consider whether the individual has satisfied all obligations, restitution, fines, fees, other obligations associated with the conviction. Similarly, when the Secretary is determining whether or not to waive grounds of inadmissibility, these same requirements should apply. These are basic issues that we should be required to be considered, and I hope all members would recognize that victims of criminal conduct have rights. They have their voice should be considered. And I would, with that, I'll yield back, Mr. Chairman.
Mr. Chairman?
Gentleman yields back. Does the gentlelady insist on a point of order?
I do not insist on my point of order.
Point of order is withdrawn.
But I would,
What purpose does the gentlelady from California seek recognition?
To strike the last word in
Lady's
opposition to the
recognized.
amendment. You know, I assume there will be a number of amendments, but I think it's important to wrap our heads around this concept. If a U.S. veteran commits an offense, they're going to have consequences. They may be sent to jail, they may have restitution, they may have fines, just as anyone else. The question is, should they have a further penalty, and that is removal from the United States? And I think the concept behind this bill, and that has been embraced by the American Legion, is that for U.S. veterans, people who put their lives on the line, they should have the accountability that anyone else has and not go that additional step further to remove them from the United States. To provide a veto to a victim, or to provide a veto if fines and forfeitures have not been met for someone who's already been removed, goes beyond what we would do for any other veteran of the United States. As a practical matter, if you have been removed from the United States and you are, a veteran sitting in Tijuana and your family is in the United States, your capacity to actually make the money to pay a fine might be severely diminished, just as a practical matter. But the point is, these veterans should be treated just like every other veteran. There should not be an additional penalty imposed for misconduct, which is removal from the country that they signed up to serve, removal from the country they put their lives on the line to serve. They're going to be treated as every other veteran would be treated and not be given the additional penalty of expulsion from the country that they served so bravely for. So this amendment should be rejected, along with any other amendment that tries to do an additional penalty above and beyond the accountability that any other veteran would have. We do not expel, we should not expel from America those individuals who signed up, put their lives on the line to protect our country, period, stop. And I yield back, Mr. Chair.
Gentlelady yields back. Does anyone else seek recognition? For what purpose does the gentlelady from Texas seek recognition?
Strike the last word.
Gentlelady's recognized.
I rise to support H.R. 7946, the Veteran Service Recognition Act of 2022, and to oppose the underlying amendment. The Trump administration made it harder to receive a certificate of honorable service, did not enforce protections for immigrant veterans, and implemented new background check requirements for non-citizens to report to basic training. This legislation is to restore honor, integrity, and justice to our immigration services for those who have faithfully served our country. These policies make naturalization significantly more difficult for non-citizens who serve in the military, subverting Congress' efforts to prioritize and protect active duty and veteran immigrants. The effects of the Trump administration policies were so drastic that naturalization of military personnel dropped from 8,770 in 2016 to just 4,570 in 2020. This is duly an affront to immigrants and a disgrace to the sacrifice of military members. This bill restores dignity to non-citizen military members by making it easier to naturalize while in the military. I'm reminded of the work we did during the Iraq War, when we helped bring families together by allowing citizen military persons to be able to move expeditiously their non-citizen family members. Remember that happening posthumously when these soldiers died in battle, because we were humane and concerned about the families and the fact that these active duty did serve and were willing to serve and die for this country. This legislation directs the Department of Homeland Security and Department of Defense to implement a program that streamlines the naturalization process for non-citizen service members during basic training or as early as otherwise possible, who deserve the respect of their country more than those who have dutifully served in the military, whether or not they're immigrant. Who else would deserve that respect? The nativism of the past administration went as far as to not just attack service members themselves, but also their families, by going to great lengths to rescind the eligibility of citizenship for military families, which we had typically done for a long time. In 2019, U.S. Citizenship and Immigration Services changed the definition of the term residence, making it so that U.S. military and other government employees stationed abroad would no longer be considered as residing in the United States, thus ineligible for U.S. citizenship. How crass and inhumane. This unfairly forced children of U.S. military members to go through a laborious naturalization process without preferential treatment due to their parents' sacrifice for their country. This bill directs the Department of Homeland Security to establish a Military Family Immigration Advisory Committee, and this committee will review the cases of non-citizen veterans and active service members through removal proceedings, and will provide recommendations on whether prosecutorial discretion is warranted or whether the removal proceedings should continue. And this will equip the Director of Homeland Security to grant special consideration to immigrants facing deportation who have served their country in the military, barring their participation in violent felony, to stop their removal. In addition, this bill allows immediate relatives of service members or veterans with an approved immigrant petition to be able to adjust their status and obtain a green card. The underlying amendment is punitive. First of all, anyone who's done a heinous crime should be assigned to their penalty. And in most instances, those individuals will be incarcerated in our prison system. At the same time, once they have paid their time, that is the way our justice system works. To suggest that those incarcerated will be plucked out of the prison, then away from their families and deported is a double penalty. They're already incarcerated, paying their penalty. They already have had victim statements when they were prosecuted and convicted. So let me give you an example. It is not a veteran, but how shameful the Department of Homeland Security, under this fearful threat from the past administration, sent a letter to one of my firefighters, a young man who loved his work, was married to a citizen, and was doing great as a firefighter in Houston. I hope I can find that young man. His wife had a panic attack, and rather than wait to be helped out of this horrible situation of getting a letter in the mail that you're about to be deported, he just simply resigned and went down to the location where his family was, missing out on his service to us and our receiving his service. We cannot run our immigration system out of fear and pain. We must run it out of respect for veterans, first responders, and others. And with that, I ask opposition to the amendment and support for the legislation. I yield back.
For what purpose does Mr. Roy seek recognition?
Speak on the Biggs Amendment.
With that, the gentleman is recognized.
I thank the chairman. I would note on the underlying measure, which I'll talk about more in a minute, the actual total number of deported veterans is unknown, but advocacy groups estimate the number to be around 300, to the best of my knowledge. And it's important to note that prior to removal, alien veterans are afforded due process through immigration removal proceedings and issued a final order of removal by an immigration judge. Now, I don't think any of us are not at least sympathetic to the question about service of a veteran and how that might affect their status in this country. But I'll have more to say about that in a minute with respect to the rules that apply to veterans, which apply to everybody. But all the gentleman from Arizona is doing, I mean, if I understand correctly, is simply saying that the literal text of the bill is that an exercise of discretion under paragraph 1A may only apply if the victim of the crime, so there was a crime and there was a victim, agrees that the individual should receive the exercise of discretion and the individual has satisfied all obligations of restitution, fines, fees, and any other obligations associated with the conviction. So all this amendment is saying, for the world to understand, is for this subset of individuals estimated to be around 300, maybe it's a little more, maybe it's a little less, even if we assume and accept the premise of the policy, which I think deserves a whole range of discussion and debate, that all that Mr. Biggs is saying is, okay, if the individual committed a crime, and our members of the military are not immune from the criminal proclivities of humankind, there are crimes committed, right? And then there's criminal justice for those crimes that are committed. So you commit a crime. And we're saying, well, don't victims have rights? And shouldn't that also be a part of the discussion about whether that individual gets permanent status in the United States, gets to stay in the United States with the how many million people that are currently in line? How many people that are, known gotaways, 850,000 known gotaways over here in the last year and a half. We've got a completely broken border. We've got millions of people waiting to get here. Now you have an individual who served, and that's to their credit, but committed a crime. And all the gentleman from Arizona, I believe, is doing is saying, should we not account for the fact that the crime was committed, that the victim have a right to be able to be heard, a right to be able to present that, hey, this individual did this thing to me.
Would the gentleman yield?
I'll yield to the gentlelady.
I thank the gentleman, and I would like to share with you the data that we received from the department in terms of.
If the gentlelady can make it reasonably.
I'll be very quick.
Expeditious.
Not all of the individuals who've been removed were convicted of anything, number one. And number two, some of the, who's the victim in a drug possession case or a nonviolent case, but additionally, it's not just consultation. This gives a veto to whoever the victim is. And
so generally, reclaiming my time,
and I thank the gentleman for
you.
you.
Run out of time. No, of course, I'm happy. I enjoy colloquies, and I think they're important. I think, number one, so not all are, committed crimes, but there are criminals. The amendment speaks to the extent to which there was a crime and there was a victim. And to the extent there was a victim, that the victim should have a say in the status of that individual in the United States. And I think that is fundamental to it. And the idea of the sort of victimless crime, right, of drug possession. The amendment speaks to that, right? I mean, I think what the gentleman from Arizona is rightly identifying is when an individual actually commits a crime, there is a victim, that the victim ought to be able to say, wait a second, why is that guy or gal getting to stay in the United States, getting the green card, getting status, getting a path to citizenship, whatever it might be, if, hey, I was the victim, right? And I thank the gentleman from Arizona. I support his amendment. I'll yield the 28 seconds to him if he wants to add anything.
I thank the gentleman. I'll just go quickly. When I hear the arguments against this, it seems consistent with the entire leftist Democrat mantra of of favoring victims over criminal defendants. This goes right to, if it's a victimless crime, if it's a DUI, let's say it's a DUI, you don't have a victim.
Gentleman yield.
This would not apply.
Gentleman yield.
It's my time and it's out. I yield back.
Gentleman's time has expired. Who seeks recognition?
I do.
What purpose does the gentleman from Rhode Island seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman, and thank you for bringing this important bill to markup. I rise in opposition to the amendment and in support of the underlying bill. With respect to the amendment, I would just say briefly, we don't have a private system of justice in this country. We have judges who make determinations and judgments all the time, but we don't allow individuals to determine the outcome of particular matters, and I think that's a very dangerous precedent, and that's why I think the amendment is not a wise one. But I want to thank you, Mr. Chairman, for bringing this really important bill to markup. Immigrants have always played an important role in our military, and their sacrifices to our country must be honored. 45,000 immigrants currently serve in our armed forces, and 2.4 million veterans, representing 13% of all veterans, are immigrants or the children of immigrants. The prior administration dismantled our immigration system, including for our immigrant veteran population, even wrongfully deporting veterans in violation of ICE policy. This legislation makes our immigration system more accessible to and fair for the brave immigrants who have fought for our country. Service members who make such incredible sacrifices for this country deserve a fair chance to make a home in the United States, regardless of their immigration status. I can think of few things that are more deserving of American citizenship than laying your life on the line for this country, our people, and our democratic values. I think the title of this bill, the Veteran Service Recognition Act, says it all. These veterans and service members must have their service recognized without burdensome hurdles. This is a matter of fairness, and we have a duty to honor our commitment to those who serve our country. I want to thank Mr. Takano for his leadership on this bill, and I urge passage of
Would
this
the gentleman
legislation,
yield?
and I'm happy to yield to the gentlelady from California.
I thank the gentleman for yielding. I just, listening to our colleague from Texas estimate that the number of people we're talking about is 300. I'm hoping that we don't spend 300 hours talking about that small group of people. There are, in this measure, provisions to protect public safety and the like. But I would note that from the information we've gotten from the MVETs that was revealed at our hearing, of the people who've applied for the administrative program, most of them are over 40. Most of the convictions are over 10 years old. Actually, the vast majority are 10 or 20 years old. It's important to note that the individuals who've been removed, they were legal permanent residents of the United States in almost every case. That's how they were able to be in the U.S. military. They could have naturalized if they had understood the process. Part of this bill is to ask our Defense Department to do a better job of having veterans, having our military personnel understand and access the naturalization opportunities. But I'll say this, all of us here, most of us here, had the good fortune, I'll just speak about myself, I feel lucky, so fortunate that I was born in the United States of America, that I'm an American citizen. I'm proud of that, and I'm grateful, and I'm happy. But I'll say this, if someone wants to sign up and risk their life in the United States military to defend our country, they're doing more to become an American than I did. I just had the good luck to be born here. And I think to strip them of their legal permanent residence, if they make a mistake after their service, is not the right thing to do. The Department of Defense estimates that up to 30% of the people who serve in our military suffer from post-traumatic stress disorder, and that is a major cause of problematic behavior, untreated PTSD. And so you have, if you take a look, and we're trying to get copies for all the members on the Republican side of the aisle, you have most of these convictions are related to, or could very well be related to the service that the individuals had. And remember, this is not an automatic right. This gives discretion to the Department of Homeland Security Secretary to take a look at a case-by-case basis to see whether there should be a return for these 300 people that Mr. Roy has talked about. And I yield back, Mr. Cicilline, with appreciation.
And I yield back, Mr. Chairman.
For what purpose does the gentleman from North Carolina seek recognition?
To speak on the amendment.
The gentleman is recognized.
I thank the chairman. And I came in late, so I was a little bit disadvantaged as I was reading the amendment and then hearing sort of the vociferous objections to it, and I didn't even understand it. I think it worth hearing, though, that what the so Mr. Roy commented on or mentioned the relatively small number of veterans who were susceptible to deportation who were known, 300 something. Ms. Lofgren just spoke to that, and there was a little bit of information about them furnished to me that I thought worth making the committee aware of. That GAO report in 2019 said 68 veterans, 78% of them, were ordered removed because of at least one aggravated felony conviction, while the remaining 19, 22%, were ordered removed for non-aggravated felony convictions. Of the convictions I cited on the 87 veterans NTAs, 32 veterans had drug-related convictions, 20 had convictions related to sexual abuse, of which 18 involved minors. 21 had convictions related to homicide, assault, or attempted homicides or assaults. 16 had theft-related convictions, and 9 had convictions related to firearms, explosives, or explosive materials. I don't really understand, as sort of to the underlying bill, why this notion that the criminal conduct of admittedly veterans, but their criminal conduct in this particular instance should be sort of wiped clean.
Would the gentleman yield?
No, I've got one more point to finish, and then I'll do that, Ms. Lofgren. Why that would be wiped clean, and then I see, you know, you could arguably say the bill doesn't do that because it imports a discretion, and I'm a little uncomfortable. We'll say I'm very uncomfortable given the administration, the Biden administration's track record on immigration. I'm reticent to furnish yet additional discretion to the Homeland Security or the Secretary of Homeland Security because of the way it's been abused. But Mr. Biggs's amendment is so modest. It simply says, so you go back to that category of the 20 who had convictions related to sexual abuse, of which 18 involved minors. And this gives deference to the victims who suffered those crimes. And then that's characterized by the gentleman from Rhode Island as being private justice. I got to tell him, get up to speed, because there's been a revolution of victims' rights recognition in the country that's been going on for 20 or 30 years now. That is not private justice. This is a very modest amendment, and it's outright rejection, and even this kind of glowing, deference to service in the military, even to the disregard of grotesque criminal conduct, I don't get. I don't think it's very balanced, and I agree, I don't think we ought to have to debate over 300 so people for an extended time, but the presentation of the bill, particularly if it's not going to be able to be modified at all in reasonable ways, unfortunately invites the situation. And yes, I do yield to the gentlelady from California.
I appreciate that. I would like to note that on page 14 and 15, there are provisions that if disqualify an applicant if there are grounds to believe the applicant is a risk to national security, if the applicant has committed or conspired to commit significant human trafficking offenses, if the applicant has been convicted of any of the following aggravated felonies: murder, rape, sexual abuse of a minor, crimes related to the operation of a prostitution ring and related human trafficking, or crimes related to the production, sale, possession of child pornography. Those cannot be waived. I would note...
Let me at that point reclaim my time. I'll give you more if I get done, but just to make the point that this 19-person advisory council is not restricted by those limitations at all. It can allow these folks in despite all those grotesque convictions. Let me yield to Mr. Tiffany.
I'll just put a finer point on this. You expect us to have full confidence in the current Secretary of Homeland Security, where the Border Patrol has said that he has lied about our border being secure, that he's done everything possible to funnel people into our country illegally, and you want us to give greater authority to him? That's reckless, and it's just wrong to do it. I yield back to the gentleman.
Let's vote. Yep.
I ask who seeks recognition, and I seek recognition, and I would yield my time to the gentlelady, Ms. Lofgren.
Yes, just a couple of clarifications here. The advisory committee that's been referenced has no authority to grant anything. They can give their advice to the secretary, but the secretary is limited by the elements of the bill itself. An applicant who has committed any of the offenses or poses any of the risks that I just read is ineligible for relief. On the issue of whether discretion can properly be exercised, as we know from our hearing, the Immigrant, Military, Members, and Veterans Initiative that the Department of Homeland Security is currently operating has received about 60 requests for relief and return to the United States from veterans and their families. Of these requests, 16 were granted and 8 were denied. So it's not as if, willy-nilly everything is going to be approved. And as for, I was a member of this committee in 1996 when we changed the definition of aggravated felony to something that is not commonly thought of as aggravated felony. The vast majority of the convictions mentioned in the GAO report are drug offenses. Now, I'm not for drug offenses. I think it's a serious problem. I know that people across, especially people who have suffered from PTSD, oftentimes turn to drugs to try and deal with the trauma that they're experiencing. That is a terrible thing. But I don't think the fact that someone has turned to drugs to solve a PTSD problem should disqualify someone from at least the potential of receiving relief. If they were a legal permanent resident of the United States, they had their status stripped after they were convicted and paid their penalty, whether it was jail or a fine, and now have been ousted from the United States and the country that they served in the military. That is not, I think, in keeping with the kind of country we want to be here, to honor those who served our country in the United States military. I would note that once again, that the advisory committee has no authority whatsoever, and the secretary is constrained, cannot consider applicants who've been convicted of any of the following aggravated felonies: murder, rape, sexual abuse of a minor, crimes relating to operation of a prostitution ring related to human trafficking, crimes related to the production, sale, or possession of child pornography, anyone who's committed or conspired to commit significant human trafficking, exceptions, or anyone, if there's a reasonable ground to believe that the applicant is a risk to national security. So I would hope that we could put our veterans ahead of our politics in this markup, and that we could come together and enact this measure that will honor our veterans. As I mentioned in my prior remarks, you know, discretion, the parole in place discretion for veterans and their families has been used many, many times. And actually, during the Trump administration, was used about 20,000 times. So this we don't have to get diverted into a partisan fight on this bill. We can come together, we can honor our veterans, and we can approve the bill and make it law. And I hope that we will. And with that, Madam Chairwoman, I yield back.
And I'll reclaim just a little bit of my time to just echo the sentiments of the gentlelady, Ms. Lofgren. I rise in opposition to the underlying, the amendment, but in support of the bill. And I'll just say from personal experience, I feel the very same thing that you said, which is I have such admiration for those who have served to defend our country in the military, citizen and immigrant. Think of the courage it takes as an immigrant and the aspiration and the inspiration it takes as an immigrant to say, I will step forward, I will risk my life for this country that I admire so much. I had two brothers serve in the Navy during the Vietnam War. One was on hospital and battleships, 2 tours of duty in Vietnam, the other stateside. I had a grandfather, Harry Eaton, who served in the Navy during World War I. I have such admiration for those who have served. I did not serve, so I hold them in awe, and I think that the underlying bill protects against the very thing that the maker of this amendment is worried about, and so with that, I yield back. For what purpose does the gentleman from Texas seek recognition?
Strike the last word.
Oh, he's up here. Oh, the gentleman is recognized.
I think people are looking at this all wrong, on my colleagues across the aisle. And in considering this, like I do, things involving the military, involving the safety of our country, as some of our Republican leaders will tell you, I don't play politics. I'm really considering what I believe is best for the country. And having represented people who were foreigners who joined the military in criminal matters, let me explain how we really should be looking at that process. People were brought in and were told, look, we're going to let you come into the United States and you're going to be on probation. You're going to serve in the military. If you serve honorably, you don't break our American laws, state laws. If you can serve honorably and well without breaking the law, then you got a shot to being a U.S. citizen, you know. So along the way, these folks committed crimes. They were getting, and please understand, they were getting paid. Usually they were provided housing or a housing allowance. They were provided medical free. All of these things were provided as part of the agreement. But as soon as they committed a crime, then they breached the agreement, and the agreement required that they go back to their home. I didn't realize that on average, these convictions were 10 to 20 years old. But I have seen, and my understanding is normally if it's a crime within the military, they may serve the sentence, they may not, they may be deported before, but usually they'll serve the sentence and then they're deported. End of contract. You breached, you pay the price for the crime. That's not part of the deal. But then the deal is you go back home. And I do know that most people that join the military, it does take courage. And especially if you're a Chinese spy and you're going to come into the United States, that takes a lot of courage to come into the military this way. But other countries that want to see our demise, they see how vulnerable we are because of this kind of thing. There was no proper vetting when people were brought in to the military for foreign countries. A lot of times they just got proof of identity. That's good enough. We don't look for the crimes they may have already committed. But this bill does not, as has been said, it doesn't consider the victims. They ought to have a voice. And let me tell you, especially in the military, drug sale, drug transfers, they're not victimless. They do more damage to the overall preparedness of our military. They do great to the military itself. The military and America's preparedness for our enemies is dramatically affected by that. So understand, there's not anything rotten about America. This program was offered in a big-hearted way, but it was an agreement. It was an agreement that was breached by these folks. When I hear people say they serve so bravely, let me tell you, having represented some folks that were engaged in this scenario, they weren't brave. They were very destructive. So just keep that in mind. They weren't all Audie Murphy, you know. So one other thing, there is not apparently going to be proper vetting because the same Homeland Security Secretary who told us that the border is secure and lied about that and has created an open, no, thank you, has left an open wound on our southern border that is just being infected worse and worse every day. We don't know who all is coming in. There's the kind of discretion we can expect. That Mayorkas will look the other way. All is good. All is right. God's in his heaven. It's all good. It's not. These are not the people to give discretion to. We need to pass this amendment.
The gentleman's time has expired. For what purpose does the gentleman from California seek recognition? The gentleman is recognized.
Thank you for yielding. I'll just point out that if you're dishonorably discharged, you're not eligible for this program. So the scenario that our colleague from Texas just outlined, that person would not be eligible. And I thank the gentleman for yielding.
I thank the gentleman very much, and let me personally thank the gentleman from California for his service in his prior life to the community as relates to safety. Let me also thank any veteran that's in the room, any veteran that is my constituent, any veteran that is in America. Because in many instances, our veterans themselves are victims of PTSD, drug abuse, substance abuse, lack of housing, homelessness, separation from their family because of their bravery on the battlefield. I know my good friend from Texas, he has a good heart, and I know he did not mean to demean veterans and to suggest that they are not worthy because some of them are doing dangerous things or creating havoc. I wasn't really understanding, but I'm going to suggest that he did not mean that, because that would be a horrible comment to make about individuals who unselfishly put on the uniform, which include those who may not be citizens or legal permanent residents. And as has been said from the gentlelady from California, this legislation only applies to those who have been honorably discharged. It is clear under the Trump administration and their nativism approach, my way or the highway, or if you have one particular heritage, you're good. If you have another, you're not. We saw a drastic decrease of naturalizations of military personnel. It dropped from 8,770 to 4,570. I have another good friend. That good friend is from Arizona. I can't let the record remain in the suggestion that Democrats are for criminals and the ones on the White Horse are for victims. How dare you? We are for the American people, and we've chosen people over politics. We believe in justice, and this legislation is about justice. And I take umbrage to anyone suggesting that we would open the keys or we're for criminals. We're for criminals who are American people who get their due process. That means victims are in that process of due process. These individuals are incarcerated. What we are suggesting is, unlike other incarcerated persons, these people are deported. And the few that would count eligible under this bill, we're suggesting that their uniform, their service, warrants them having a second chance or not just being automatically deported. Democrats fight for Americans, and they fight for people who have been victimized by crime, their own family members, members who have been on this panel. So it'd be an untoward comment to juxtapose the idea of that we choose one group over another. As I said, we choose due process, justice, equality, democracy, fairness. And we embrace victims as they are needed to be embraced. I guess that's why we have fought so hard for the children who lost their lives in Uvalde, because we do feel the pain of the victims and victims' families. That's why we supported legislation that this very side stayed hours to rebut gun safety laws. Those are victims. Nobody seemed to be sympathetic there in the terms of what we were trying to do. So I just simply believe this is a very important legislative initiative, and I'd hope that we would all know that we care about all people and that we look at this bill on the merits of it and not suggest that one group versus another loves victims or loves criminals. We are for the American people, and we're for veterans, and we believe that victims should be embraced and supported, and we believe that men and women who put on the uniform and bled, as some of them have, deserve this legislation. They happen to be permanent legal resident and have not been able to become a citizen, to get a double, we all know double jeopardy is not the American way. They're incarcerated and then they're deported. That does not happen to others who are likewise incarcerated. So I ask to oppose the amendment. I yield back to the chair. I yield back to the gentleman. I thank the gentleman for his kindness.
For what purpose does the gentleman from Ohio seek recognition?
Yield to the gentleman from North Carolina.
Gentleman is recognized.
I thank the gentleman from Ohio, and I don't seek to engage in the debate with the gentlelady from Texas about concern for victims' rights. I think that there's enough evidence on that to be drawn from the experience of the citizens of New York City, Baltimore, Chicago, San Francisco, to make people's independent judgments on that. But I do think it's worth engaging with the gentlelady from California on what she said about the structure of this bill. Because I don't think it gets everything out that it needs to. She suggested, the gentlelady, Ms. Lofgren, that there are guardrails on the ability of the secretary to act, to grant discretion under this. But let me explain that, what I read, a little more closely. In Section 7 of the bill, if someone has been issued an order of final removal or they have been deported, then the guardrails that the lady described are there. They can't get an additional consideration to be brought back into the country or have the removal order canceled or rendered ineffective if they've been guilty of terrorism, sex trafficking in persons, murder, rape, child sex, child exploitation, prostitution, maybe another one I can't read. However, the issue is under this advisory council, that's under Section 4, and that operates in a different circumstance. That operates when someone is eligible for removal, but has not been removed, there's no removal order yet, and they have not already been deported. And in that case, the advisory council can recommend parole, it can recommend deferred action, it can recommend a stay of removal. And although literally the secretary is not bound by the decision of the advisory council, it is a 19-member advisory council, and the legislation does explicitly require the secretary to make regular reports to the advisory committee, quote, including detailed explanations for any cases in which a recommendation of the advisory committee was not followed. That certainly creates a pathway or creates what is likely to happen in the overwhelming majority of circumstances. There are no guardrails for those who are in the United States, commit crimes, and on the predicate of their having served in the military are exempted from the processes of immigration law.
Would the gentleman yield?
It's not my time. I'll yield back to the gentleman from Ohio, but I'd love to engage in colloquy because that's how I understand it to operate.
Yield to the gentlelady.
It's not a 19-member, it's a 9-member board, and it's advisory.
I don't think that's probably material.
Just a note. It's advisory in removal proceedings, and it has no authority. So you could have a situation where a person, well, this is something that our colleague Bobby Scott used to talk about, where you have an 18-year-old engaging in relations with a 16-year-old, and it results in a conviction. You could have the advisory board say, well, this was consensual, even though you can't give consent when you're 16. That could be weighed, but it doesn't have any legal authority. It doesn't have, and it's only in removal proceedings. It's not for return of one of the 300 who is sitting in Tijuana waiting for, and I thank the gentleman for yielding.
I thank the gentlelady for that point. I think the bigger point is that this is a transmission belt to this, for how this process will occur. Yes, in an extraordinary case, there could come to pass that there would be an agreement, a disagreement between the advisory council and the secretary may refuse it. It's not going to ever happen in practicality. It might happen once in a blue moon. But the big point is that the guardrails the gentlelady described are not on the table to constrain any action that would prevent removal from being commenced against someone, and for all the future in which this law would presumably apply, and the numbers grow well beyond the 300 that appeared covered in the GAO report, all the new cases are wide open for maximum discretion in this advisory council without any guardrails. I yield back to the gentleman.
Would the gentleman yield? Because in removal proceedings, you have an immigration judge, you have the attorney, the prosecutor, and occasionally you have a defense counsel. Today, in every single removal proceeding in America, there is the prosecutor can use discretion. That's the case in every single courthouse in America, including immigration court. So this doesn't change that.
The gentleman's time has expired. The chair recognizes that votes have been called, so we will see if one more member seeks recognition. For what purpose does the gentlewoman from Washington seek recognition?
Madam Chair, I move to strike the last word.
The gentlewoman is recognized.
Thank you. I would like to speak in opposition to the amendment and for the bill, and I would just start with bringing us back to the purpose of the bill. Immigrants have defended the United States in every major conflict since the Revolutionary War. In fact, one of the first casualties in the Iraq War was of Lance Corporal Jose Antonio Gutierrez, who was not an American citizen when he died fighting for the United States. At age 17, he made the 2,000-mile dangerous journey by train, foot, and bus to the United States from Guatemala. He was adopted by a family in the United States, and he joined the Marines, wanting to give back to the country that gave him everything. Today, there are 45,000 immigrants serving in the U.S. Armed Forces, many of them likely motivated to enlist for the same reasons as Jose Antonio Gutierrez. And yet hundreds of immigrant veterans are estimated to have been deported. The Veteran Service Recognition Act would take the crucial steps necessary to stop this from happening and to provide relief to veterans who have already been deported. And as you've heard from Representative Lofgren, the guardrails are actually very, very strong. The truth is that this bill shouldn't be necessary. The idea of deporting individuals who enlisted in the military, who are ready to put their lives on the line to defend the American people and our democracy, is just wrong. And, you know, it's tragic when a service member comes home suffering from PTSD, makes a mistake, and is banished from the country that they fought to defend without any consideration for their services. Now, some of my colleagues on the other side would have you believe that many of these service members should not be granted legal status because of interaction with the criminal justice system. But we know that 11 to 30% of veterans have PTSD or have experienced some form of it from that very act of defending our country. And we also know that people suffering from PTSD are 60% more likely to become entangled in the criminal justice system. When people have suffered trauma, especially, but certainly when it's in service to this country, we should be responding with treatment and help, not handcuffs and jail. And for immigrant veterans, we have to ensure that they're not deported from the country that they risk their lives for. Immigration and Customs Enforcement is supposed to consider veteran services to this country when making removal decisions. But a 2019 GAO study found that ICE attorneys, quote, did not consistently follow its policies involving veterans who were placed in removal proceedings, in part because ICE officials were unaware of the policies. That's a direct quote. We can't leave this to chance. Even one deported veteran is too many. And when people sign up to defend this country, we should be helping them to become US citizens as quickly as possible. And that's exactly what the bill.
Would the gentlelady yield? Would the
I would.
gentlelady? I want to thank you for pointing that out, that the ICE prosecutors didn't realize that they should consider the veteran status. And that's the major reason for this advisory committee, to at least heighten the awareness of the prosecutors. Here's a vet, and that needs to be part of the consideration. They don't have a say. They shouldn't have a say. That's going to be, the prosecutor, and maybe there'll be a defense counsel and the judge, but at least they'll know this is a vet, and that's a real reason why we put the advisory committee in there, and I thank the gentlelady for yielding.
Very, very important point. Thank you, Representative Lofgren. We're also talking about a very limited number of individuals. Estimates put the number of deported veterans in the hundreds. DHS has already demonstrated that it's highly capable to help facilitate the return of deported veterans through the Immigrant Military Members and Veterans Initiative. As of June, the IMMVI team has received 60 requests for relief and return from veterans and their family members. So far, the team has granted 16 of those requests and denied 8. So these numbers just refute the fear-mongering from the other side. This program to return deported veterans to their families and communities is working. The individuals are carefully vetted and denied when warranted. I'm proud that President Biden has taken action to prevent and address deported veterans early in his administration, but now Congress needs to do our part. And that starts with passing this bill. I urge my colleagues to vote yes on the underlying bill and no on the amendment. I yield back, Madam Chair.
The gentlelady yields back. We have 2 votes on the House floor. Therefore, the committee will stand in recess until immediately after the conclusion of those 2 votes. The committee stands in recess.
So the Judiciary Committee will come to order after our brief recess for votes on the floor. It's my understanding that Mr. McClintock would like to strike the last word.
No,
You're
actually, I'd like to
recognized for 5
speak on the amendment under the
Correct.
5-minute rule. Thank you, Madam Chairman. I just wanted to begin by offering a few translations of the bureaucraties and gobbledygook that we've heard in description of this bill. One description was, well, we thank our veterans for their service by deporting them. Well, no, we deport them because they committed crimes and were ordered removed by a court of law. We're told, well, the bill's very narrow. Well, except for one thing, it presumes that any alien, not just one who served in the military, any alien by virtue of lawful permanent residence is presumed to have established good moral character. But the best was, well, they just messed up. What that means is they committed crimes. Now, what Mr. Biggs' amendment says is that the victims of their crimes ought to have a say before they're admitted back into the country, or at least the convicted criminal should be required to pay the fines that they were assessed for their crimes before they're allowed back into the country. This provision extends far beyond just the foreign veteran who committed crimes and was deported. This bill includes family members who've been ordered deported, and it extends to any person with a green card the automatic presumption that they've proven good moral character. Now, one member said, well, we don't have a private justice system, and that is absolutely true. We have a public justice system based upon due process of law. Now, what the bill says is that after you've had due process and it's run its course, and after an immigration judge orders removal, then Ali Mayorkas and his committee can overturn that judgment, ignore the law, and reverse that decision and ignore the victims. This bill says, well, Mayorkas can ignore the entire judicial process, but he can't ignore the victims. Yeah, at least we should ask the victims of these crimes to have a say in whether the criminal who impacted their lives should be left back in the country, and to place the few criminals who served in the military alongside the many law-abiding immigrants who served in the military is a remarkable insult and injustice to our law-abiding veterans. It said, well, the bill puts people over politics. No, it puts criminals over victims. And I'll yield my time to Mr.
Would the gentleman yield?
Thank you. I thank the gentleman for yielding to me. I want to put this in context, and I think Mr. McClintock has done a great job putting it in context. First of all, the current state of law is a non-citizen serving in the military is going to gain status. Second of all, this bill focuses on criminals. That's what it's focusing on, criminals. Criminals who've had their day in court. They've had due process, as Mr. McClintock pointed out. It also goes to their family members. This bill says if you've been removed from the country as a criminal having been convicted of committing certain crimes after receiving due process both in the immigration courts and the criminal courts, that you cannot, the Secretary cannot not allow you back in, doesn't have the ability to waive those things. But if you have not yet been removed, the committee is under no such constraint. They can provide a recommendation that you remain in the country. And while that's maybe non-binding, the Secretary is still required to report back to that committee, that advisory committee, on what the Secretary has done vis-a-vis that recommendation. Now, let's consider, because the argument has been made, well, the victims are accounted for because the Secretary is constrained, but that's only post-removal after the veteran has been convicted and had due process under immigration laws. So here's the way it works. Aggravated felony. These are the only aggravated felonies that bind the Secretary. Murder, rape, sexual abuse of a minor, child pornography, and in some sexual trafficking cases. But it doesn't preclude the Secretary from allowing in people who have committed a crime of violence for which the term of imprisonment is at least 1 year. No, that's an aggravated felony. Nor does it proscribe or constrain the Secretary on any of the other aggravated felonies listed in the title. That is the problem. And the one group of people that are not considered at all are the victims. I'm just saying, why don't we consider the victims? Let them have their say. Let them participate. That's what I'm saying here. And with that, I'll yield back to the gentleman from California.
Thank you. I'll yield to my friend from California in the remaining moments.
Thank you, Mr. McClintock. I believe it's clear that the section on page 14, the provision relative to clarification is only about veteran non-citizens, but if the gentleman is concerned that that is not clear, we'd be happy to ask unanimous consent to make it clearer that it's veterans, non-citizens, that
I
it's not
appreciate that,
intended.
because our analysis is pretty clear on the point. It involves any alien. So if
Well,
you're willing to amend the bill.
I don't think
to
it does,
make
but
that-
we do not want any uncertainty on it, and so we will ask unanimous consent to insert veteran non-citizens in
Thank
the
you for making a
appropriate
terrible
sections.
bill a bad bill.
So without objection, that amendment will be adopted, and I now recognize Ms. Escobar to strike the last word. You're recognized for 5 minutes.
Thank you, Madam Chair, and I'd first like to express my strong support for this bill, which I think is an act of patriotism to recognize the women and men who have so selflessly served on behalf of our nation. It honors our veterans, it honors our commitment to veterans, and I cannot imagine that anyone in the U.S. Congress would vote against our veterans. Having said that, I would like to yield the remainder of my time to the distinguished gentleman from California who has been a champion for all veterans, but especially deported veterans, Mr. Correa.
Thank you, Ms. Escobar. Just wanted to say and remind folks that due process does not guarantee justice. So we have veterans that are convicted, do their time, pay their price, pay their crime, restitution, and then they're deported. So they pay twice for a crime. In America today, we hold veterans to a higher position in our society. We appreciate their sacrifices for our country. And that's why we have what are called veterans courts. Veterans courts recognize that veterans do run into the law. They have troubles. But if you're a veteran and you enter a veterans court, for drug offenses, for other offenses, you have a different track to follow, to be rehabilitated, to again address those invisible wounds that you may have brought back from the battlefield. We want to get you back on your feet. I've had the opportunity to visit deported veterans in Tijuana, Mexico a few times. It's interesting to see what they've done out there. They've gotten together, they built what's called a bunker where they live, big American flag, and this is their place. I've had the opportunity to talk to a number of them. I remember one individual struck up a conversation, told me he had done 8 tours of duty in Afghanistan. And I said, so what happened? He said, one day I woke up, was choking my wife in the middle of the night. Was convicted and deported. All these individuals, all these deported veterans are honorably discharged. They have followed the laws, have served our country with honor. Then something happens in their lives. Most of these convictions are, of course, for drug and other offenses. But they are veterans. And I think we have to remember that they are veterans. They took an oath to defend our Constitution, our nation, and took a pledge of allegiance to our flag. Not to a foreign flag, not to the flag of their birth, but to the American flag. And for that, we are not recognizing their sacrifices. Most of these veterans, deported veterans, are from the Philippines because of the active participations of Filipinos in our military. I just ask this committee, our members, we can nitpick this bill to death, but we ought to talk about how to make this good legislation that'll honor the service, the sacrifice, our immigrant veterans, their contribution to this great country. Thank you very much, and I yield the remainder of the time to Ms. Escobar.
Thank you, Mr. Correa. Madam Chair, I yield back.
The lady yields back. Does anyone wish to be recognized further? Hearing no one, then the question occurs on the amendment made by Mr. Biggs. All those in favor will say aye. All those opposed will say no. No. In the opinion of the chair, the noes have it, and a roll call is requested. Clerk will call the roll, please.
Mr. Nadler? Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Deutsch? Ms. Bass? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Raskin? No. Mr. Raskin votes no. Ms. Stripal? Ms. Stimmings? Ms. Stimmings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Ms. McBath? Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean? Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush? Mr. Jordan? Mr. Shabbat? Mr. Gomert?
Yeah, that's aye.
Mr. Gomert votes aye. Mr. Issa? Mr. Issa votes yes. Mr. Buck?
Aye.
Mr. Buck votes aye. Mr. Gates?
Aye.
Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Stube?
Yes.
Mr. Stube votes yes. Mr. Tiffany?
Tiffany, aye.
Mr. Tiffany votes aye. Mr. Massey? Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes yes. Ms. Fishbach?
Yes.
Ms. Fishbach votes yes. Ms. Sparts? Mr. Fitzgerald? Mr. Benz?
Mr. Benz votes yes.
Mr. Benz votes yes. Mr. Owens? Mr. Owens votes aye.
How is Swallow recorded?
Mr. Swalwell, you're not recorded.
No.
Mr. Swalwell votes no. Mr. Nadler, you are not recorded.
I vote no.
Mr. Nadler votes no.
Madam Speaker, how am I recorded? Hank Johnson.
Mr. Johnson, you are not recorded.
Vote no, and I've got Sheila Jackson Lee on this line.
Madam Clerk, how am I recorded?
Ms. Jackson Lee, you are not recorded.
I vote no.
Ms. Jackson Lee votes no. Mr. Johnson of Georgia votes no.
Mr. Chairman, how am I recorded?
Ms. McBath, you are not recorded.
McBath votes no.
How is
Ms.
Mr.
McBath
Shabbat recorded?
Mr. Shabbat, you are not recorded. Mr. Shabbat votes aye.
How am I recorded, Mr. Chairman?
Mr. Deutsch, you are not recorded.
No.
Mr. Deutsch votes no.
Clerk will report.
Madam Chair, there are 15 ayes and 16 noes.
The amendment is not adopted. Are there any further amendments to the bill?
Madam Chair,
Mr. Biggs,
I have an amendment at the desk.
clerk will report, and a point of order is reserved by Mr. Correa.
Amendment to the amendment in the nature of a substitute to H.R. 7946, offered by Mr. Biggs of Arizona. Page 14, line 20, strike quote 3 and insert quote 36E quote. Page 14, beginning on line 23, strike quote or K quote and insert quote K or N quote.
The gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Madam Chair. Again, I just want to clarify, the current state of the law is a non-citizen serving in the military gains legal status by virtue of service, or a change in status potentially. But this bill is focusing on what happens when someone is ordered removed, and has been ordered to be removed, or is in that process. And for the vast majority of these, we've heard repeatedly, is for criminals. These people have committed crimes. The Secretary cannot waive the removal and entertain repatriation for certain criminal conduct. The advisory committee is not so constrained. But the Secretary must report on how the Secretary has responded to that advice. The advisory committee deals with the pre-removal process and not the repatriation necessarily. So this amendment is interesting because I've in previous markup, some Democrats expressed a desire to work with me to address human smuggling. And I was told that while they understood that we must address human smuggling, that bill was not the appropriate bill at that time to address the issue. Well, today I'm offering an amendment to ensure that aliens who engage in smuggling activities are not eligible for the benefits of this bill. And I hope my colleagues still agree that we must address the issue of human smuggling and will support my amendment. The law is clear. Says any alien who at any time knowingly has encouraged, induced, assisted, abetted, or aided any other alien to enter or to try to enter the United States in violation of law is inadmissible. That sounds a lot like potentially dealing with the cartels. As drafted, however, the bill allows the Secretary to specifically waive this ground of inadmissibility. I don't know why the majority chose to allow smugglers to benefit from this bill, but I hope that they will recognize that this should not be allowed and will support my amendment. This amendment won't necessarily stop smugglers, but it will perhaps be a deterrent, and it certainly will prevent rewarding human smugglers. I urge the adoption of this amendment, and I'll yield back.
The gentleman yields back. The gentleman from California does not insist on his point of order, I'm sure, since the amendment is germane. And I will recognize myself in opposition to the amendment. I would note that the underlying bill already includes, as a prohibition for consideration by the Secretary, 212A2H, which is significant traffickers in persons. The sections that the gentleman seeks to include as non-waivable includes offenses that in some cases can be minor. And let me give you a real-life example of someone who I actually know who fell into this category. This person, I'll call him Juan, was a legal permanent resident of the United States, and he had a birthday, and he and his girlfriend went to Tijuana, and they really had a great party, and he became inebriated. And because he didn't want to drive drunk, he had his girlfriend drive his truck back across the border. Well, Juan was a legal permanent resident of the United States, but unfortunately, his girlfriend was not. And so when they attempted to re-enter, he was charged with alien smuggling because it was his truck and she was driving, and she was undocumented. Obviously, because she was undocumented, she was not going to be admitted, but that is a real-life circumstance that I happen to deal with as an immigration lawyer, where, you know, the Secretary, if Juan were a veteran of the United States and did several tours of duty in Afghanistan, you might want to consider whether or not that was an extreme enough offense to require that veteran to be deported to another country. This is discretionary only, and we do want to make sure that people who are in the cartels, people who are involved in significant alien smuggling may not be considered for relief, but I think the gentleman's amendments would preclude consideration of potentially meritorious cases. Obviously, this is limited to veterans, and as we know from the track record so far, about half of the applicants have been rejected by the Secretary. The fact that you can at least be considered doesn't mean that you're going to receive approval. So I would urge, I'm sure that the gentleman's intentions are the best, but I think the amendment is unnecessary and would urge its defeat. And with that, I would yield back my time. Do other members wish to be heard on this amendment? If not, then the question occurs on the amendment. All those in favor will say aye. All those opposed will say no. No.
No.
In the opinion of the chair, the noes, and Mr. McClintock asked for a roll call, so the clerk will please call the roll.
Mr. Nadler?
Spearhead that, and even when they got to the Senate,
Please
they
mute.
tried to
Please mute.
Ms. Lofgren?
No.
Ms. Lofgren votes no.
I'm going to move quickly.
Ms. Jackson Lee?
Ms. Bush, you need to mute. Ms. Bush.
No.
Ms. Jackson Lee votes no.
And if not, we will.
Ms. Bush, please
Mr.
mute.
Cohen?
No.
Mr. Cohen votes no.
No.
Mr. Cohen votes no. Mr. Johnson of Georgia? Mr. Deutsch? Ms. Bass? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu? Mr. Raskin? Mr. Raskin votes no. Ms. Stripal? Ms. Stripal?
No.
Ms. Stripal votes no. Ms. Stimmings? Ms. Stimmings votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Ms. McBath? Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
Dean votes no.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross?
Ross votes.
Ms. Ross votes no. Ms. Bush? Mr. Jordan? Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert?
Aye.
Mr. Gomert votes aye. Mr.
Thank you.
Issa? Mr. Issa votes aye. Mr. Buck?
Aye.
Mr. Buck votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Stube?
Yes.
Mr. Stube votes yes. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes aye. Ms. Fishbach? Ms. Fishbach votes aye. Ms. Sparts? Mr. Fitzgerald?
Aye.
Mr. Fitzgerald votes aye. Mr. Bentz?
Aye. Mr. Bentz votes aye.
Mr. Bentz votes aye. Mr. Owens? Mr. Owens votes aye.
How is the chairman recorded?
Mr. Nadler is not recorded.
I vote aye. I vote no.
Mr. Nadler votes no.
Adler votes no.
Mr. Johnson? How is Mr. Johnson?
Mr. Johnson of Georgia is not recorded.
How am I recorded?
Mr. Deutsch, you are not recorded.
No.
Mr. Johnson, you need to unmute in order to vote.
Mr. Deutsch votes no.
Mr. Chairman, how am I recorded? This is Mr. Neguse.
Mr. Neguse, you are not recorded.
Neguse votes no.
Mr. Neguse votes no.
Madam Chair, how am I recorded?
Mr. Liu, you are not recorded.
Lou votes no.
Mr. Liu votes no.
How is
Madam Chair, this is Congressman Jeffries.
How am I recorded?
Mr. Jeffries, you are not recorded.
Jeffries votes no.
Mr. Jeffries votes no.
How is Mr. Johnson recorded?
Madam Speaker, how am I recorded?
Mr. Johnson, you are not recorded.
No.
Mr. Johnson of Georgia votes no.
Okay. You know what my situation?
Are there any other members wishing to record their vote or to change their vote? If not, then the clerk will please report.
Madam Chair, Congressman Tiffany.
Oh, before the clerk reports, Mr. Tiffany, how are you?
Mr. Johnson needs to vote.
Tiffany, aye. Thank you very much, Madam Chair.
Mr. Tiffany votes aye.
Ms. Jackson Lee, how would you wish to vote?
Aye. And Mr. Johnson got disconnected. I was trying to help him.
Mr. Johnson has voted no. How would you like to
All right,
vote, Ms.
great.
Jackson Lee?
No.
Ms. Jackson Lee votes no.
Mr. Chairman, how am I recorded?
Ms. McBath, you are not recorded.
McBath votes no.
Ms. McBath votes no.
Do additional members wish to be recorded? If not, the clerk will report now.
Madam Chair, there are 16 ayes and 22 noes.
And the amendment is not agreed to. I would like to recognize myself for a unanimous consent request to address the issue that Mr. McClintock raised that we thought was covered, but we want to make it abundantly clear. We would insert by unanimous consent on page 15, line 21, strike non-citizens and insert non-citizen veteran status under this section. And it's my understanding this language has been worked out between the council for both the Republican and the Democratic side, making this abundantly clear. So without objection, that will be adopted. Are there additional members wishing to be recognized?
Madam Chair, I have an amendment at the desk.
Gentlemen, clerk will distribute the amendment, and Mr. Correa reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 7946, offered by Mr. Biggs of Arizona, page 14, line 20. Strike quote 3, quote, and insert quote 310D, quote.
Gentleman is recognized for 5 minutes to explain his amendment.
Thank you very much, Madam Chair. Again, I want to remind everybody that's here, those who may be watching now or in the future, is that the current state of the law is that non-citizens serving in the military are protected. But this bill, the underlying bill, focuses on those who have been removed because they've been convicted of criminal conduct or are in the process of being having their status adjudicated because they've committed and been convicted of a crime. The Secretary cannot waive and bring people back into the country if they've committed certain limited crimes. The advisory committee is not so constrained and can recommend prior to removal that somebody who has committed a crime, including aggravated felonies under the statutes, that they be allowed to remain in the country. The Secretary is required to report to the advisory committee the Secretary's performance vis-a-vis the advisory committee's recommendations. I suggested that maybe the victims of these crimes should be heard before a change in status one way or the other, either by the advisory committee or by the Secretary. The majority rejected
Would
hearing
the gentleman
from
suspend for just an inquiry? Because
Yes, I'll suspend.
I think you are discussing a different amendment than what was passed out. Yeah, 10D.
Yeah, I'm getting there. Let's just call it the warm-up.
Okay, I'm sorry. I just wanted to make sure we were all on the same
I may be taking a little bit longer in the warm-up than you anticipated, Madam Chair.
Okay, that's fine. We'll make sure you're
I'm
not.
trying to provide context for this.
All right, we'll make sure you're not shorted on your time. Thank you.
That's fair enough, thank you. So the first point being, I brought up, victims should be heard before you either remove or return, right? So that'd be the first thing. And then I followed that up by saying, well, if you're a human smuggler, you should not be able to be brought back into the country, or that should not be waived as well. That should be considered. So, and I didn't get anywhere with those two. So I thought maybe what you're interested in is something that I hope wouldn't be as controversial. And so this amendment adds unlawful voting as a ground of inadmissibility that cannot be waived by the Secretary. So I didn't think that would be controversial, but I'm probably wrong. I hope that we all agree that individuals who voted illegally should not be rewarded. As currently drafted, this bill allows the Secretary to allow individuals who voted illegally to receive the benefits of this bill. And the other bill that we're going to consider today specifically prevents the Secretary from providing relief to aliens who voted illegally for some reason. This bill omitted that provision. And my amendment will make the two bills consistent in this regard. I urge the support, and I'll yield back. And I think I finally got around to that, what the amendment's about,
Okay.
Madam Chair.
All right, and the gentleman yields back. I recognize myself, Mr. Correa withdraws his point of order. His amendment is germane, and I recognize myself in opposition to the amendment. The prohibition on voting, unlawful voters, is one that does not actually have a knowledge requirement. And, well, I'll give you an example of someone, an individual who would be excluded from benefit. A veteran, his name is Paul Canton. When he joined the military, his recollection is that the recruiter promised him that he would automatically become a U.S. citizen if he served 4 years and had an honorable discharge. So he served 4 years, he received an honorable discharge, and then he re-upped for 4 more years on inactive reserves, and during his time in the U.S. Marine Corps, he was awarded a National Defense Medal, a letter of appreciation, a service employment ribbon, a good conduct medal, and a rifle marksman badge. Now, following the completion of his military service, he believed, and he was incorrect, that he was automatically a U.S. citizen, and believing that he was eligible, he voted in several elections. He is married to a United States citizen. He has 2 teenage sons, one of whom is planning to follow in his father's footsteps and join the United States Marine Corps. But because his mistaken belief that he was a U.S. citizen is no excuse for his unlawful voting, he is at risk of being deported. Now, I think that we need to have a case-by-case review of these circumstances. I will say also this, that although some have suggested that there's widespread voter fraud, there's really almost no evidence to support that suggestion. A 2014 Harvard study found that the likely percent of non-citizen voters in recent U.S. elections is 0. The 2017 Brennan Center analysis found that non-citizen voting is vanishingly rare. If you take a look at the code, the only exception in terms of a knowledge situation is a mix-up with an adoptee. I'll give you another real-life example. This is someone, again, from my immigration background, a woman who she was orphaned, And her older brother told her that she was born in San Diego. And they were actually in the circus business, and they would go back and forth across the border very frequently. And he told her this because he didn't want her to say she wasn't a U.S. citizen. She grew up believing she was a U.S. citizen. And it wasn't until she was in her 50s and she and her U.S. citizen husband went to go get their passports that she found out that her brother had lied to her, and she wasn't, in fact, a U.S. citizen. She lived all her life, married a U.S. citizen, had her children, and couldn't get her passport. She had been a voter because she thought it was her responsibility. She never in a million years dreamed that it was illegal. So this happens from time to time, not often, and we need to have at least the capacity to consider the facts. This would remove that capacity, and therefore I think it would be a mistake to adopt this amendment. With that, I would yield back my time. What purpose does Mr. Shabbat seek recognition?
Move to strike the last word,
And the
Madam
gentleman's recognized for 5 minutes.
Thank you, Madam Chair. I support Mr. Biggs' amendment and commend him for offering it. I'd like to address my comments to the bill overall. One of the most rewarding parts of this job, I find, is working with veterans and recognizing and honoring the sacrifices that so many of them have made for our country. Every community in this nation is blessed to have men and women who have bravely placed themselves in harm's way to defend our values and our freedoms. We must never forget their sacrifices or the debt that we owe to veterans of all ages and all backgrounds. This Congress, this particular Congress, and those in the past, I've taken a number of steps along with my colleagues on issues that impact veterans' care and benefits, and I'm going to continue to do and support those things that do support the veterans community, such as helping some veterans to overcome addiction, which is often coupled with post-traumatic stress disorder. In my district in Cincinnati, for example, the Joseph House is leading the way on that front, and they and the veterans that they serve need and deserve our support. I've been there many times over the years, and they improve their services on an ongoing basis, and they're really a great organization. Organizations like the Joseph House are critical in providing additional resources outside the VA so that all veterans have access to the help that they need, regardless of where they live. My concern with this legislation is principally twofold. First, it authorizes the Secretary of Homeland Security to issue a green card to alien veterans who have committed removal offenses, been afforded due process in an immigration court, and ordered removed by an immigration judge. These individuals have already had their day in court. Second, it would also allow the Secretary of Homeland Security to prevent the removal of an alien who previously served in the military, but who would otherwise be subject to removal for committing a serious crime, like drug trafficking or assault with a deadly weapon or trafficking in weapons and a number of other major crimes. So they've committed a crime. Veterans and service members are already provided with special avenues towards naturalization. In fact, during the last 5 fiscal years, USCIS naturalized nearly 30,000 service members. Most importantly, though, before considering legislation like the one before us today, we ought to focus our efforts on securing our southern border. The truth is that the situation at that border is an unmitigated disaster. And unfortunately, the massive influx of illegal border crossings that we're currently experiencing allows human trafficking networks to flourish. They're making a tremendous amount of money on the backs of the people that they're exploiting. The legislation before us today, unfortunately, is not at its core really about service members and veterans who have fought on behalf of this country, but instead is just another attempt to weaken U.S. immigration law rather than secure our border. Our border is something that makes us a country. Unfortunately, the Biden administration has reversed all the policies that were actually working in the previous administration. They've ended the building of the wall. Those materials are laying rusting out there, and the American taxpayers paid for those things. The people come into this country, they're put by the administration on a plane or on a bus. They're shipped all over the country, and members of Congress continue to be refused when they've asked for information about where these folks are going. The administration keeps that secret away from members of Congress as well as away from the press. It's an absolute, I think, an abomination of what the administration has been doing for quite some time, and it's getting worse. So I would strongly urge this committee to focus on legislation that would benefit veterans and ensure the safety and security of all Americans. We can do both of those things. We can help veterans, but we can also help the public overall by making sure that we have a secure southern border, which we certainly do not have now. And I yield back.
Gentleman yields back. Do additional members wish to be heard on this amendment? If not, then Mr. McClintock?
If I could just add one thought, and that is
Gentleman's recognized for 5 minutes.
we keep hearing this notion that, well, this is just going to be applied on a case-by-case basis. Yet this administration has a record of granting blanket paroles or refusing to enforce the laws by claiming prosecutorial discretion, not on a case-by-case basis, but rather across the board on the basis of membership in an entire class. So asking to extend a power to an administration that has amply demonstrated a willingness, in fact, an eagerness to abuse the authority to make case-by-case decisions, I think is asking for too much. You know, a judge or a jury already can take individual personal considerations into account without giving Ali Mayorkas the power to override these decisions made in our courts by substituting his and his advisory committee's judgment for that of this process. So with that, I'll yield back.
Gentleman yields back. The question occurs on the amendment. All those in favor will say aye. Aye. All those opposed will say no. No. In the opinion of the chair, the noes have it. A recorded vote has been requested. The clerk will please call the roll.
Mr. Nadler. Ms. Lofgren.
No.
Ms. Lofgren votes no. Ms. Jackson-Lee.
No.
Ms. Jackson-Lee votes no. Mr. Cohen. Mr. Johnson of Georgia. Mr. Deutsch. Ms. Bass. Mr. Jeffries. Mr. Cicilline. Mr. Cicilline votes no. Mr. Swalwell. Mr. Liu.
Lou votes no.
Mr. Liu votes no. Mr. Raskin. Ms. Drypal. Ms. Stimmings. Ms. Stimmings votes no. Mr. Correa.
No.
Mr. Correa votes no. Ms. Scanlon.
No.
Ms. Scanlon votes no. Ms. Garcia.
No.
Ms. Garcia votes no. Mr. Neguse. Ms. McBath.
McBath votes no.
Ms. McBath votes no. Mr. Stanton.
No.
Mr. Stanton votes no. Ms. Dean?
Dean votes no.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush? Mr. Jordan? Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert?
Aye.
Mr. Gomert votes aye. Mr. Isa?
Congressman Issa votes yes.
Mr. Isa votes yes. Mr. Buck?
Aye.
Mr. Buck votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Stube?
Yes.
Mr. Stube votes yes. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes yes. Ms. Fishbach? Ms. Fishbach votes yes. Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz?
Mr. Benz votes yes.
Mr. Benz votes yes. Mr. Owens? Mr. Owens votes aye.
Nadler votes no.
Mr. Nadler votes no.
Swalwell is no.
Ms. Jayapal?
Jayapal votes no.
Ms. Jayapal votes no.
Mr. Raskin?
Mr.
Mr.
Caldwell
Swalwell.
votes no.
Mr. Swalwell votes no.
Mr. Cohen votes no.
Mr. Cohen votes no.
Johnson of Georgia votes no.
Mr. Johnson of Georgia votes no.
How is Mr. Raskin recorded?
Mr. Raskin votes no.
We weren't sure how.
Are there additional, are there additional members wishing to cast or change their vote? Mr. Jeffries, you need to unmute so we can hear you.
Sorry, Madam Chair. How am I recorded?
Mr. Jeffries, you are not recorded.
Jeffries votes no.
Mr. Jeffries votes no.
Are there additional members wishing to vote or to change their vote? If not, the clerk will report, please.
Madam Chair, there are 15 ayes and 20 noes.
And the amendment is not agreed to. Are there additional members wishing recognition to be recognized at this time? Mr. Johnson?
Madam Speaker, I have an amendment at the desk.
Clerk will report, and a point of order is reserved by Ms. Escobar.
Madam Chair, I reserve a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 7496, offered by Mr. Johnson of Louisiana. Strike Section 7.
The gentleman is recognized for 5 minutes in support of his amendment, and the point of order is not insisted on since this is obviously germane. Mr. Johnson.
Thank you, Madam Chair. This amendment would eliminate all of Section 7 of the bill, and that section allows those veterans who have already been removed or given a final order of removal to both return and be granted lawful permanent residency, which is the most important step on the path to citizenship, as we know. But here's the problem. It gives the Secretary of Homeland Security carte blanche authority, unilateral authority to waive nearly any ground for inadmissibility for these non-citizen veterans. It gives the Secretary total discretion to give this lawful permanent residency
This is a problem because under this section, veterans who are removed at any time in the past can return even if they've been living for decades in another country. There's nothing in this bill that requires the Secretary to review their actions while in that other country, such as whether they may be enlisted in another military force, maybe an opposition force to our country, or worked for a government that is unfriendly to the U.S. And these veterans had plenty of opportunity, of course, to apply for citizenship during their service or within 6 months of departing from the U.S. Armed Forces. They, for whatever reason, chose not to. All these veterans who were removed were afforded due process through immigration removal proceedings. There are about 300 alien veterans in this section would apply to. We're talking about 300 individuals. Only 144 of them have applied for relief thus far. Representative Biggs introduced amendments that would address this section, such as allowing non-citizen veterans who smuggled people into the country or illegally voted in U.S. elections to return. Representative Fitzgerald introduced an amendment that would make non-citizen veterans who engaged in drug trafficking ineligible for return. But this amendment, instead of taking a piecemeal approach like that, would just strike the entire section and remove the ability of these veterans who were properly removed from returning. In summary, I would just say that, I mean, this could really apply to anybody, any non-citizen veteran who committed multiple crimes, trafficked in drugs, smuggled humans across the border, engaged in international child abduction, and illegally voted in U.S. elections. There's no limit to it. It's not a parade of horribles. These are all possibilities, and it gives one person, the Secretary of Homeland Security, the authority to review and make the decision on the matter. I just think it's too weighty. I don't think it's right. I think it's fraught for abuse and risk, and for that reason, I ask my colleagues to support the amendment. I yield back.
Gentleman yields back. I recognize myself in opposition to the amendment. First, there is an online portal using parole authority that we have discussed at our hearing on the subject of deported veterans. The gentleman asserts that there have been 144 requests for repatriation. Actually, that is requests for assistance. And if the veterans were discharged honorably, they do have a right to veterans benefits. And so some of these are pursuing the veterans benefits that they earned through their service. There have, according to the report that we received during our hearing, there have been 60 applications for relief and to repatriation to the United States from veterans and their family members. Of these requests, 16 have been granted and 8 have been denied, and the rest are pending. The gentleman's amendment would essentially gut the bill, and I must note that it is not correct that the Secretary has complete discretion. In fact, as we discussed earlier on our first amendment, the bill prohibits the Secretary from granting relief if there are reasonable grounds to believe the applicant is a risk to national security, if the applicant has committed or conspired to commit significant human trafficking offenses, if the applicant has been convicted of any of the following aggravated felonies: murder, rape, sexual abuse of a minor, crimes related to the operation of a prostitution ring and related human trafficking, or crimes related to the production, sale, or possession of child pornography. I would note also that individuals who have been removed have not always been removed because of criminal convictions. For example, of the individuals who applied for relief with the Department of Homeland Security under the administrative program, there were crimes of violence, 38, sale or distribution of drugs and related offenses, 43, drug possession, 12, sexual offense, 14, nonviolent offense, 19, no convictions, 10. So I assume that, but we can certainly find out, that the 8 that were denied were in the category not of no convictions. The age of the criminal convictions is also of interest because 2 of them were between 0 and 4 years old, 16 were between 5 and 9 years old, but 53 were between 10 and 19 years old, and 55 were over 20 years old. These individuals have served both in the war on terrorism, but also they're Vietnam War vets, as well as Persian Gulf conflict members. The bulk of them served honorably, or else they would not be considered. So I think this amendment, I understand the gentleman may not support the bill and may vote against it, but this amendment would simply gut the bill, and I would urge that we reject the amendment. And with that, I yield back. Are there other individuals wishing to be? Mr. Issa.
Thank you, Madam Chair. I'll be voting no on the underlying bill. I'll be voting yes on this amendment. And I just want to, and I do not intend to talk long and hard on these bills. These bills are inherently wrong-minded and represent the worst of what the majority is trying to do to this country. I'll take up the particular of striking the paragraph 7. I'm a veteran, and for those who are not, I hold no special status, but perhaps I hold a special understanding. This reckless bill does not require that these people being considered were honorably discharged. Their crimes could have in fact been within the military. Their discharges were not because they ceased to be a veteran. If you're discharged dishonorably, you're still a veteran. But if you're discharged other than honorably, how dare anyone consider the government or the military service as grounds to have them come back? That is exactly what you don't want to have. This bill ultimately is about people who have given up their rightful request to get the benefit of American citizenship because of their actions. Whether it's a small crime or a big crime, it's a crime. And I'm personally offended as a veteran that it includes special treatment for those who have potentially committed crimes. And I know the gentlelady, rightfully so, said the vast majority might be honorable or general. That's probably true. But the fact that you took no care to exclude those who have...
Would the gentleman yield?
I will in a moment. Other than honorably, offends me. So I'll be voting no, but even if this were not there, even if you struck this, gutted the bill, as you said, there's still the basic question of, we have over 2 million people this year that will come here and be granted admittance here. I have been to the border and I've seen this wholesale crossing of the border. Those people aren't going home. A very few people will be adjudicated and removed. And what you want to do is make sure that those who have been adjudicated and removed are able to come back. Those who go through this long and laborious process, those who we hunt down after they don't show up, and you want to bring them back. Now, I'm going to just close my statement with, I've had constituents who, by the way, were registered to vote, but illegal. They didn't happen to vote. And the gentleman was an executive with, he'd worked his way up through the ranks of the cable company, but he was discovered after more than 20 years. He and his wife had both come here just after the 1980s amnesty, and they'd been here. They'd had children here that were American citizens who knew no other country. And I not just sympathized with them, but I looked for every legal way to find an exception that would allow that family to remain here. Because it did seem like we had had a broken system for a very long time, and they had simply played into our broken system, and yet they had committed no other crimes. They had lived a wonderful life. She was active in the church, and he had worked his way up through the ranks. I have those examples in my district every day, as all of us in California and around the country mostly do. We should be focusing on real immigration reform and trying to figure out a way to fix a broken system, to send the right message to the right people. But today, as we look at second chances for those who were rightfully removed because, quote, we want to bring them back, I'm sorry, Madam Chair, but it's wrong-minded. This legislation is just wrong-minded. You'll have me as a partner for sensible legislation. You'll have me for sensible enforcement. You not only don't have me today, but you have me absolutely almost beyond words, and I'd yield to the lady.
I thank the gentleman for yielding. On page 20, the term veteran is defined in Section 101, Title 38 of the U.S. Code. Section 38 of the U.S. Code 101-2 says the term veteran means a person who served in the active military, naval, air, or space service and who is discharged or released therefrom under conditions other than dishonorable. These are individuals who are eligible for benefits.
Quickly retain my time just to respond. Other than dishonorable leaves bad conduct, general, in addition to honorable. There are others. You can commit a crime, you can be tried and convicted under the UCMJ and not dishonorably discharged.
I just wanted to make it clear.
I appreciate it, but you could have made it those who served honorably, and you should have if you wanted to even be considered.
These are
for my vote.
individuals who are eligible for VA benefits, and I thank the gentleman for yielding. And does Mr. Bishop wish to be recognized?
I do. Thank you.
Gentleman, his strikes the last word.
I will say that I think the point that Mr. Issa was making is quite palpable, and I had another iteration of some of the contrast that comes to mind. There's a young man that I've known since he was a Cub Scout, lives in my district that I currently serve. He has had a very promising career in the Navy as a young E3, a seaman, and had been accepted for SEAL training until the military decided to destroy his career in the military because he declined to take the vaccine that we were told by science, by the public health establishment, would keep people from being infected. He is virtually, the risk to him is non-existent. He's a 22-year-old young man. But he had been accepted into SEAL training, so he was removed from SEAL training last October. And since October, he has been kept stagnant, nothing to do, no responsibilities, cannot get out of the Navy until until the processing occurs on their own sweet time. This 22-year-old has been held for 9 months. And I recently, it took me going to 4 members of Congress to intercede with the Personnel Command to get his damn paper signed so that he can get out of the military and get on with his life. We also saw in the NDAA last year the provision on extremism in the military, with the declining to define what extremism was, but allowing the Secretary of Defense to define it any way he chose, and to root people out of the military across the board on the premise that there's some widespread extremism in their midst.
Good.
This is from the same party that in this bill suggests that this bill in which you want to give special treatment to criminals because they were non-American citizens who served in the military at some point in time and not even necessarily honorably discharged, to the point of the gentleman from California. It's mystifying to me. And I thought about not bringing it up, but it just doesn't add up. And I think it provides context for this bill. I cannot understand why the President of the United States and the Democratic Party has wreaked the destruction on young men and women in our military service at the beginning of their careers or in the midst of careers with extraordinarily expensive training having been paid for by the American people. But you've done it blithely, without any apparent concern. You've even been reluctant to make any adjustment the best they could do is keep them from having dishonorable discharges. So spare me use the phraseology from and I won't finish the phraseology from the gentleman from Rhode Island in a recent hearing, spare me the assertion that the concern is for veterans of the United States military, because you're not treating the veterans in the United States and you're not treating the current members of the military with any respect whatsoever. You're destroying their lives. And with that,
Will the gentleman yield?
Yield to the gentleman from Texas.
And I would just ask the gentleman from North Carolina that young man who is 22 years old, did he receive a general discharge or an honorable discharge?
You know, candidly, I think it's a general discharge.
That is my understanding. That is a general discharge and not an honorable discharge,
and to this
which
day,
raises the whole point.
I wish I could name him out loud in front of America because he still isn't out of the military.
Right.
I've gotten the order signed finally by jumping up and down and pulling everything I could to get it done. And then you can't get his command promptly to transmit the order and get the young man out. It's like these are the most contemptuous individuals I've ever seen. And that's what the treatment is that is routinely being visited upon our members of the military. So spare me, as I say, that the pressing need for this to come before this committee is so illegal aliens who are have been in the United States military at some point in time and have been removed for criminal conduct. That's who the priority is. I yield back.
Gentleman yields back. Who seeks recognition? Ms. Gentleman from Florida is recognized to strike the last word.
Thank you, Madam Chair. I yield to the gentleman from Louisiana, Mr. Johnson.
I thank my friend, the gentleman from Florida. Listen, regarding what you gentlemen were just talking about here, I just pulled this up. Examples of actions that could lead to an other than honorable discharge include security violations, use of violence, conviction by a civilian court with a sentence including prison time, or being found guilty of adultery in a divorce hearing. That's not a definitive list. Those are only examples. But here's the irony, I think, that sticks out in all this. Today, we are hearing articulated this new zeal to allow extra measures of respect and deference to veterans, which everybody on this side of the aisle obviously agrees with. But it's really ironic because it was just last week, just a number of days ago, my amendment to do that in the context of the Cicilline gun control bill was flatly, even vehemently denied by every Democrat on this committee. They insisted that veterans who honorably served the country and know how to handle a firearm, who are specifically trained in that, could not be trusted to be exempted as a category like law enforcement officials in their big gun control bill. But the section of the bill that we're talking about here, Section 7, is really something, because what we're saying here, and for people back home who are watching this, look, the Secretary of Homeland Security has total discretion under the bill to give lawful permanent residency to a veteran, even if that non-citizen veteran committed multiple crimes, trafficked in drugs, smuggled humans across the border, engaged in international child abduction, illegally voted in U.S. elections, you name it. So here's the question, and I mean, this is a good faith question. I'm asked the chair if she would entertain it. You said, if effectively in your comments, what I took from that is you said, well, yeah, okay, don't worry. The Secretary has total discretion, but the Secretary of DHH is going to watch that. Don't worry, you know. Why would we allow even the discretion for these categories? I do not understand it. It is madness to me. Why would we not just put it in your bill and say these categories are not allowed? Why would you allow the DHS Secretary to even determine that? It doesn't make any sense. Do you have an answer to that question, Madam Chair?
If the gentleman would yield, if you would read the bill, there are several sections that remove discretion, I've mentioned them before, from the Secretary in terms of applicants who are risk to national security, applicants who have committed or conspired to commit significant human trafficking offenses, an applicant who's been convicted of any of the following aggravated felonies: murder, rape, sexual abuse of a minor, crimes related to the operation of a prostitution ring, and related human trafficking, crimes related to the production, sale, or possession of child pornography. And I would just note further that the general discharge, I would presume that the young man that Mr. Bishop knows who declined the vaccine, that he would not have a dishonorable discharge, that he would have a general discharge, just as someone who has committed adultery would get a general discharge, not a dishonorable discharge. And I hope that clarifies this for you, Mr. Johnson. I yield back.
I thank you for your response. I would say it doesn't clarify it, but because I just don't know why we would even allow for this to be a gray area at all. I yield back to the gentleman from Florida.
I take some umbrage with the chair's comparison of refusing an experimental vaccine to committing adultery and suggesting that those ought to be treated the same way in our military. And I think of how many constituents I have who, by virtue of their faith, which is the value set for many of their marriages that they hold so precious, they are having to separate from a military in a country that desperately need them. And I often meet with the spouses.
Gentlemen, yield.
Yes.
I certainly did not indicate that the adultery and vaccine refusal were the same. I just noted they would both be a cause for general discharge.
Well, I guess my point is I appreciate that. Someone should not be treated the same way for both of those two things because both of those things should not be punished, right? Adultery in the military, perhaps, our standard is to punish that with this type of a discharge. We should not be doing that with people who refuse the vaccine, especially because I see so many of my constituents who are refusing the vaccine, and I see the pain and the challenge that it puts upon their marriages and upon their families, but they're sticking to their faith nonetheless. So I would make that note, and I'd yield back the balance of my time.
Gentleman yields back. If there is no further request from Mr. Roy, you are recognized to strike the last word.
I thank the chair. I will not use all the time here in this window because I still have not spoken directly on the underlying bill, and I know we're on the amendment. But I do have to at least just interject and respond. Obviously, I engaged in a very brief colloquy with the gentleman from North Carolina, but it is absolutely extraordinary to me, notwithstanding, I think, the reasonable debate about ensuring that those who serve in our military do so honorably, do so following our laws, and serve that they're able to get status or maintain status, and that, of course, being the existing law. But then this question here about then when there's a violation of our criminal codes, what happens to those who served in the military and what happens to their status? I mean, some of those conversations are at least reasonable to have, as the gentleman from California, who I don't think remains in the room anymore, was raising himself. But literally we're here spending time bending over as far as we can bend, for individuals who have gone through, had due process, and engaged in some criminal conduct. And I realize the gentlelady is going to say there's all these exceptions for these horrible crimes. There's been a back and forth about whether or not the advisory committee would essentially allow an end run to that. We've debated that. I won't repeat it. But we're sitting here bending over backwards. And to the point of the gentleman from Florida and the gentleman from Louisiana, the gentleman from North Carolina, we have individuals, some 60,000 that are sitting on the chopping block right now, who are serving their country honorably and are facing general discharge, a 19-year service member, a major in my office, reduced to the point of emotion, tears, because he's being forced out of the military.
Would the gentleman yield?
Briefly, out of respect for the gentlelady.
As you're well aware, the Judiciary Committee doesn't have jurisdiction over those policies. That's the Armed Services Committee.
I am aware, and reclaiming my time, I am aware, but this policy is being driven solely and entirely by my Democratic colleagues. That it is being driven by the Democratic leadership of this administration, the appointees of the Department of Defense, and by the Democratic leadership in this body literally refusing to engage in any legislation we want to try to offer to be able to protect our service members from being discharged, not even honorably, for failing to take a vaccine that even if we just objectively look at it, can all agree is a politicized question. When the CDC director herself, hardly a bastion of what I would consider objective production of public health for the American people, has raised all of the questions about the benefit of the vaccine with respect to transmission. Say, well, and they reduced to, it's beneficial for the member. Well, then let the member decide. And so again, we're looking at a population of 300 people. And again, I don't mind having the conversation, but I oppose the legislation for a variety of reasons. I'll get into it more in a minute. I think the gentleman's amendment is well taken. I think this is another one of these amendments that we're simply trying to say, is there any limit to which my colleagues on the other side of the aisle won't reach to find some path and be able to allow for the discretion of the secretary. We're not even getting to the bill that's coming up on the docket here later, which is absolutely freaking deranged, to give the kind of absurd flexibility to this secretary who can't even acknowledge that we have a crisis at our border, and he looks at us and lies, straight up lies to the American people, to us, that we have operational control of the border. We'll get to that bill in a minute, but all of this is in context. All of it. It's all in the context of the fact that we have an administration literally refuses to acknowledge the situation at the border and does not give a whit about what it does to the people, and is perfectly content giving as much flexibility to the secretary to ignore the laws of the United States to have wide open borders to the damage of the people. And here we are again, extending and bending backwards. So with that, I will yield back my time.
Gentleman yields back. If there are no further requests for time, the question is on the amendment. All those who are in favor will say aye.
Aye.
All those who are opposed will say no. No. In the opinion of the chair, the noes have it. A roll call is requested. The clerk will please call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Deutsch? Ms. Bass?
Right, this is what I'm looking at. She's calling the.
Someone needs to mute. Thank you.
Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin? Ms. Jayapal? Ms. Jayapal votes no. Ms. Stimmings? Ms. Stimmings votes no. Mr. Correa?
No.
Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse? Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean? Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross? Ms. Ross votes no. Ms. Bush? Mr.
Mr.
Jordan?
Cohen votes no.
Mr. Jordan? Mr. Jordan votes yes. Mr. Shabbat? Aye. Mr. Shabbat votes aye. Mr. Gomert? Aye. Mr. Gomert votes aye. Mr. Issa? Mr. Issa?
Mr. Issa votes aye.
Mr. Issa votes aye. Mr. Buck?
Aye.
Mr. Buck votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Aye. Mr. Johnson of Louisiana votes aye. Mr. Biggs?
You're right there.
Mr. Biggs votes aye. Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Stube?
Yes.
Mr. Stube votes yes. Mr. Tiffany?
Tiffany, aye.
Mr. Tiffany votes aye. Mr. Massey? Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes aye. Ms. Fishbach? Ms. Fishbach votes aye. Ms. Sparts? Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz? Mr. Benz votes aye. Mr. Owens? Mr. Owens votes aye.
Mr.
Baz here.
Yes.
And to revise section 2 according to Barnabas.
How is Mr. Cohen recorded?
Mr. Cohen, you are not recorded.
I'd like to be recorded as no.
Mr. Cohen.
How is Jackson Lee recorded? You got to stop
How am I recorded?
unmuting me so I can't
Jackson
speak.
Lee is recognized.
Yeah. I vote no.
Ms. Jackson Lee
Is that
votes
the-
no.
Ms. Bass.
Baz votes no.
Ms. Bass votes no.
Am I recorded?
Mr. Deutsch, you are not recorded.
No.
Mr. Deutsch votes no.
Has Ms. McBath been recorded? Are there other members who wish to be recorded or who wish to change their vote? If not, the clerk will report.
Madam Chair, there are 18 ayes and 19 noes.
And the amendment is not agreed to. Are there additional amendments to be offered?
Madam Chair, I have an amendment at the desk.
Gentleman has an amendment, and a point of order is reserved by Ms. Escobar. Clerk will report the amendment, please.
Madam Chair, I reserve a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 7946, offered by Mr. Fitzgerald of Wisconsin. Page 8, insert after line 25 the following. For disqualifying violations, in conducting each case review under paragraph 1, the advisory committee shall consider as factors precluding a recommendation under paragraph 1A, the commission of a violation described in section 212A2A12 of the Immigration and Nationality Act, or a conviction described in section 237A2B1 of such act. Page 14, line 23, insert after subparagraph A the following B.
The gentleman is recognized to explain his amendment for 5 minutes. Mr. Fitzgerald.
Thank you, Madam Chair. This kind of goes in line with some of the other amendments that we've already considered here this afternoon. So obviously what's happening down at the border is at a crisis point, has been for some time. But along with that is obviously the opioid epidemic. And I know that many members, when you've been down there, specifically if you talk to Homeland Security, I mean, they can tell you just how many drugs are coming across. But I introduced a bill last year that would designate fentanyl as a Schedule I drug, which in my estimation closes the loophole in current law. And as most of us do, we have a strong record on veterans issues. But it seems that the bill continues to target kind of sympathetic populations. And what this would ultimately do is erode the ability for law enforcement to get a handle on immigration, right? So this part, and I just wanted to go back to something that we were talking about earlier, because I think there was a question as to, how do non-citizens end up in the military? So to join the U.S. military, non-citizens must be living permanently and legally in the United States. Non-citizens must also have permission to work in the United States, which means you possess an I-551 permanent residence card, and you have to have a high school diploma and you have to speak English. I think all those requirements are up to date. So there's kind of this group that's been carved out, I think, and we're going back to kind of, should Secretary Mayorkas have this magic wand and suddenly say that those otherwise that would be removed for obvious reasons, because they've committed some type of crime, and specifically the one that this amendment addresses is trafficking fentanyl, that there would not be a way for them to simply say, just ignore all that and move forward. So this amendment would prevent both the advisory committee from blocking removal of these convicted of drug crimes, as well as granting green cards to illegal aliens. So let me summarize even further. So the amendment, quote, the illicit trafficking in a controlled substance, what you'd be doing is adding this to the list of crimes for which a deported veteran cannot receive a green card from the DHS secretary, and preclude the advisory committee from making a recommendation for an exercise of discretion from the advisory committee for the same offense. The other thing I just want to mention is, because I think honorable discharge and general discharge have been thrown around a lot today as well. You know, for somebody that's been discharged because they would not take the vaccine, for them to get a general discharge, the only other place that it's commonly used that I'm aware of is if you've got somebody a kid that signs up and joins the Army, and then within a 2-week, 3-week period, they realize that suddenly it's not a good fit. This kid's not a good fit for the Army agrees this kid's not a good fit, and they just give a general discharge because, you know, no harm, no fault, everybody just kind of goes on their own way. But when you take a veteran, you take somebody that served honorably for, like Mr. Roy said, example, 19 years. I mean, high ranking, and has probably been deployed. And then you simply say to them, oh, by the way, we're going to give you a general discharge. That is a slap in the face. It's a slap in the face. I don't care how you frame it up. It's something that obviously should never happen. And I think that's what's really, sorry, I'm getting off of the topic of the amendment a little bit, but that's what's really irritating, I think, to many of these individuals that have served honorably, as well as their families, is that you literally have left them out in the cold. And it's something that needs to be addressed. My office is inundated still with emails from these individuals that are currently being separated as we sit here today. And it's something that should be addressed. And I wish the majority would take it more seriously. So, and I yield back.
Gentleman yields back. The point of order is not insisted on because the amendment is germane, and I recognize myself in opposition to the amendment. Here's why this amendment should not be supported. In the first part of the amendment, the advisory committee shall consider, they can consider anything, but this would preclude a recommendation if there was a offense that was a moral turpitude, which is anything from petty theft to something serious. And I think that would limit the ability of the advisory committee to really raise the issue that here's a veteran in removal proceedings. Here's what the advisory committee is to consider the following positive factors. If the individual was an enlisted member or officer of the armed forces, if they received a medal or decoration, if they were deployed, if they were evaluated for merit in their service and the like, if they've contributed to their local community during their service in the armed forces. It is assumed, I think correctly, that it is the prosecutor who will raise the issues that are negative about the individual before us. As to the second part of the amendment, in 1996, we amended the act so that aggravated felony was expanded beyond its traditional understanding. It's not, you think convicted drug trafficker, it could be El Chapo. Well, that's a guy who should not get, who's a thug and a murderer. But under our immigration laws, selling $10 worth of marijuana is also, under the law, an aggravated felony. And there's no distinction made between outrageous drug traffickers and somebody who grew a marijuana plant in their backyard. I do think that a veteran who served honorably, who was a legal permanent resident of the United States, but didn't obtain his citizenship, should not be precluded from consideration for repatriation for a marijuana plant in his backyard. And so I don't think this amendment is well taken. I would urge that I'd be happy to yield.
Thank you, Madam Chair. I guess going back just a little bit, you had talked a little bit about what the advisory committee can consider, and you said they can consider whatever they want. And as I look at the language on page 7 and 8, it looks very prescriptive, and so if I'm missing where it says they can consider anything they want, I would love to know.
Well, if reclaiming my time, they shall consider this. It doesn't preclude them from considering other matters. To be honest, if the amendment did not include, I'm trying to find this. If we struck on line 3 as factors precluding a recommendation under paragraph 1A, I wouldn't have a problem with the first part of this amendment. It's the preclusion provision that I could not accept, and then, of course, page 14, I've described why that couldn't be acceptable.
Would the chair yield?
I'd be happy to yield.
Thank you, Madam Chair. I guess I am reading this a little bit differently because it does say the advisory committee shall consider.
Yes.
And then it goes through with respect to the member of the armed forces, and it goes through things. It does not say and other items they may find.
It does not preclude consideration of other items.
Well, shall is a pretty strong
Yeah,
word.
they can't, reclaiming my time, omit to look at these items. But it's advisory in any case. I'm hoping that we can get a vote on this amendment because we do have a classified briefing at 2 o'clock, and I think members wish to attend that classified briefing, and we might
thank you, ma'am.
recess. Unless there's further debate on the amendment, the question is on the amendment. All those in favor will say aye. Aye. All those opposed will say no. No. In the opinion of the chair, the noes have it.
Roll call.
A roll call is requested. Clerk will call the roll.
Mr. Nadler. Ms. Lofgren.
No.
Ms. Lofgren votes no. Ms. Jackson-Lee. Mr. Cohen. Mr. Johnson of Georgia. Mr. Deutsch. Ms. Bass.
I wonder if I may interrupt. I am going to ask that we recess now and continue the vote, because otherwise members here will not be able to get to the classified briefing, which is in the Capitol basement, in time for the beginning. And I think that's unfair to members.
Would that also mean that this amendment? I think we have to.
Or do we have to finish the parliamentary? We have to finish this now, because all the members are going to miss the start of the classified briefing. I think we'll withdraw the request for the if you'll withdraw the request, and we will recognize you as soon as we reconvene to reinstate your request for a recorded vote.
Madam Chair, I would hope we could finish the roll call first.
All right, then members are going to miss the start of the classified briefing. The clerk will continue.
Ms. Bass? Ms. Bass votes no. Mr. Jeffries? Mr. Cicilline? Mr. Swalwell?
No.
Mr. Swalwell votes no. Mr. Liu?
No.
Mr. Liu votes no. Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Ms. Stimmings? Ms. Stimmings votes no. Mr. Correa?
Excuse me, no.
Mr. Correa votes no. Ms. Scanlon?
No.
Ms. Scanlon votes no. Ms. Garcia?
No.
Ms. Garcia votes no. Mr. Neguse?
No.
Mr. Neguse votes no. Ms. McBath?
No.
Ms. McBath votes no. Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean? Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Ms. Ross? Ms. Ross votes no. Ms. Bush? Mr. Jordan? Mr. Jordan votes yes. Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Issa?
Aye. Aye.
Mr. Issa votes aye. Mr. Buck?
Aye.
Mr. Buck votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Aye. Mr. McClintock votes aye. Mr. Stubbe?
Yes.
Mr. Stubbe votes yes. Mr. Tiffany?
Tiffany, aye.
Mr. Tiffany votes aye. Mr. Massey? Mr. Massey votes aye. Mr. Roy? Mr. Roy votes aye. Mr. Bishop? Mr. Bishop votes aye. Ms. Fishbach? Ms. Fishbach votes aye. Ms. Sparts? Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz? Mr. Benz votes yes. Mr. Owens? Mr. Owens votes aye.
Nadler votes no.
Mr. Nadler votes no.
Madam Clerk, Cicilline votes no.
Mr. Cicilline votes no.
Are there additional members wishing to?
Madam Speaker, how am I recorded?
Mr. Johnson, you need to turn on your camera to vote. Meanwhile, Mr. Cohen has his camera on. How is Mr. Cohen recorded?
In the negative.
Mr. Cohen votes no.
Thank you.
Ms. Jackson Lee?
How am I recorded?
Ms. Jackson Lee, you are not recorded.
How am I recorded?
Ms. Jackson Lee, you are not recorded.
Ms. Jackson Lee, do you wish to vote no or yes?
How am I recorded? Hello?
You're not recorded. Vote no or yes.
What is this? Sorry.
The chair voted no.
Jackson Lee votes no.
Ms. Jackson Lee votes no.
You have it on?
Yeah.
Okay.
Yeah, you have to do this.
Mr. Johnson, are you able to turn on your camera? Oh, Mr. Johnson, how do you vote?
Just speak.
No.
Mr. Johnson of Georgia votes no.
Are there additional members wishing to vote or change their vote? If not, then the clerk will report.
Madam
Madam Chair, there are 19 ayes and 21 noes.
And the amendment is not agreed to. The committee will be in recess until after the classified briefing. Members will then please return to the committee room promptly after that. We're in recess.